Wait,
There we go.
Okay.
Sorry.
Okay.
You know those moments when you're typing your password and you're like, wait, what is my password?
Don't say it out loud, you're online.
Yeah, right,
To
Okay,
answer the question, yes, amen. Somebody emailed.
call the meeting to order at, what is it, 12:10?
13.
13. So first on the docket is reviewing the edits to the policy and procedures that Damien sent to us earlier this morning. Damien, do you want to walk us through
I
those?
will. I'm gonna log into the meeting. Unless, yeah, would it be helpful?
I
if
think
we
yeah,
put the screen?
it's good practice to put it up there.
Sorry, I was late.
No, it's okay. We know you are doing important work on everyone's behalf. Better than us drafting it ourselves.
Much better.
Yeah. Yeah. The punctuation would be horrendous. Yeah.
I was gonna say, that's why I have editors.
Yeah.
So. Okay. Oh. There it is. Okay.
Oh, that's nice.
Sorry, I'm just getting all of the. I guess you guys can't see everything on my screen. Huh? Anyway, the first change here, we didn't discuss this last time, but as I was proofreading, I realized that this is out of date. We had defined potential complainant as a person identified by a witness or other individual as a person who may have experienced discrimination, but it really is, the way we use it is a person who may have experienced discrimination or retaliation. So that's just a change really to make it consistent with the way the policy is currently worded. So the next rule here is, instead of saying informally contacting the panel, just contacting the panel. And then any person may contact a member of the panel to discuss an incident or conduct or inquire about the policy without initiating the panel's complaint process. So this makes it clear that you're also there to answer questions about the policy. And then the other changes here are just technical, adding in the words potential complainant and changing all the references to an informal resolution to just a resolution. Okay. Again, the top of this page, we are also changing the references to the informal resolution or informal contact to just a resolution or contact. And then in every instance in which a panel member is contacted regarding an incident or conduct, so not just an inquiry, the panel member shall inform the potential complainant and any other person, rather than listing everyone out, who has communicated with the panel member regarding the incident or conduct, that regardless of whether the potential complainant wishes to pursue a resolution, panel member has to inform the other panel members about it. Panel may need to gather additional information, and the panel is obligated to take immediate and appropriate action. The current policy provides to ensure that the conduct that violates the policy does not continue. I'm proposing changing that to prevent conduct that violates the policy from continuing, because it's not necessarily a guarantee that the action you take is going to
have
stop
the result that
someone.
we want, right,
Yeah.
right. Ensure is not.
Yeah, you can't ensure that your steps will prevent the conduct from continuing. Your obligation under the law is to take steps that are reasonably calculated to prevent the conduct from continuing.
No, that's better.
So, Representative Burrows, you had a question?
I find the construction of that part to be confusing. And I wonder whether it would be whether it would be more explicit if it says prevent from continuing conduct that violates the policy.
Oh, yeah, in other words, not breaking up.
Yeah.
Or prevent the continuation of yeah.
You see what I mean?
Yeah. I can wordsmith it. Yeah, I guess we could say she's obligated to take immediate and appropriate action. And it really is may need to take immediate and appropriate action to prevent. Yeah, I guess to prevent from continuing. That also reads awkwardly to me.
It does. Yeah, I know. I know.
How do you want it to read?
So, yeah.
As you have it now, how would you read that sentence?
Yeah. Because I'm not sure what's stricken there, what's being stricken. Okay.
So this is how it would read. Whoop.
Yeah,
Yeah, that reads,
Is it?
well, because we are obligated to take action, well, immediate and appropriate action if there is conduct that is violating the policy.
right.
Mhm.
That's not it. It's the
We're continuing part, yeah.
Yeah, we could say, we could also say
Seems clear the way it's written.
prevent ongoing conduct, or prevent the continuation of
I think
conduct.
prevent the continuation.
Condition of conduct that violates the policy.
Yeah, we could do that.
That, yeah, that.
So we're gonna move
matters.
the word continue.
Yeah.
Mhm.
Just think a few years ago, we couldn't do what I just did.
I know, isn't that crazy?
That would have required running back to my office, to my desktop. So,
Long way.
yeah, we have. So the stricken language in D is repeated in Rule 3 below. So it's just duplicative.
Great.
Or the struck language, stricken. It's been a long day. My blood
It's
sugar's
only
low.
noon.
Yeah. So this is called somewhat clunkily resolution process without formal complaint, to try to really make clear that you don't need to file a formal complaint to resolve things. I haven't been able to think of a better way to phrase it. If any of you think of
Do
something.
we need to have the words without formal complaint?
We
there?
don't need to. This was something that the sexual harassment panel did because they wanted to make it extra clear that you don't have to file a formal complaint to resolve your issue.
Or have the panel engage in the process. It's not.
Yeah.
What about resolution without formal complaint?
That would work.
It's important to have the without
Yeah.
formal complaint part in there.
And I'll
Yeah.
play with the formatting. So again, in A and B, we're just changing the informal resolution to a resolution, or I guess it's just an A. And then in C, we're listing out different types of resolution. I tried to list them generally to reflect that we can do mediation, we can do a facilitated dialogue, and we can also just discuss the incident or conduct with the respondent, which was sort of the only option under the old policy. And otherwise, I couldn't think of any other resolution options. We can always add them later. And so it's in consultation with the complainant and with consent of the regulated individual. So it's a voluntary process.
The fact that the list is preceded by may attempt any of the following, is that limiting? Is there a way of making that not limiting language, like that,
That
those
makes-
three are the only ones that,
Yeah, you could say may attempt a resolution in consultation with the complainant and with the consent of the regulated individual, including, yep.
I'd rather have it be, you know, if someone comes up with
something
with
different.
another process that would lead to the same
We should
type
be
of
limited,
conversation,
yeah.
right? And because terminology is changing constantly.
Yes. Well, for example, facilitated dialogue would include a restorative circle as well as
Yeah.
multiple other processes
I
that are
just
out there.
wouldn't want us to get hung up on
These are
the title of a something if it falls
Mhm.
under what is clearly intended to reach a resolution.
Right. And, you know, it's also worth noting too, you know, discussion of the incident or conduct with the respondent is one approach, but if the individual who, you know, if you have an incident where a third party outside of the legislature engages in the conduct, it may not be appropriate to have a dialogue with them. It may be appropriate to send a letter or to reach out to their supervisor. So something like that. So again, I think including is good. It leaves flexibility if the facts of the situation present you with something where you have a member that may not have another avenue.
Yeah.
And the panel may not have jurisdiction to take some sort of formal action, but can still say, we became aware of this. Please take steps to ensure that it stops. And then the confidentiality, rather than repeating the confidentiality standard throughout, and then having to try to incorporate all of the nuances of it, I'm just saying, shall be kept confidential pursuant to Rule 20. And then if the complainant is not present for the resolution, panel members shall notify the complainant of the outcome, because we no longer are just requiring that it be a meeting. And then just technical changes here. Because we've eliminated the commas in the last clause, we no longer need to use semicolons. So that's the semicolon to comma change there. Really excited
Yeah.
grammatical issues.
Again,
And
better
then-
you than us.
This is again where the editors come in because I didn't catch that. So, and again, down here, when you're limiting the identities, it's the identity of the complainant or the regulated individual or of any witness or other person that communicated with the panel regarding the incident or conduct. Preventative action, we're just updating this to refer to the resolutions available pursuant to Rule 3 or a formal complaint. So just to clarify between them. Rule 5, the update here allows for formal complaints regarding conduct that occurred during official General Assembly events between the date on which the member was elected and the date on which they were formally sworn in. And then subsection F is the issue we discussed where someone files a formal complaint and realizes that what they wanted was a mediated discussion. So this allows them to stay their complaint and pursue a resolution under Rule 3. We can then skip ahead. So the one change I've made here is that if the complaint contains allegations that may constitute a violation of the House or Senate policy for the prevention of sexual harassment, rather than the General Assembly, because those policies are very similar, but slightly different. So yeah, just to clarify. You can go all the way down to the burden of proof for a hearing. So this is Rule 13. You asked for the alternative language. So this would provide, instead of the current burden of proof, which is clear and convincing evidence, it would make the burden of proof preponderance of the evidence. So more likely than not, rather than meeting the higher standard, meaning that you have to have the evidence that's certain, unambiguous, and plain, evidence that the conduct occurred, and that is reasonable and persuasive enough to cause the panel to believe that the conduct occurred, rather than just to conclude that it's more likely than not that the conduct occurred. This is a perennial question that comes up. In the past, the clear and convincing evidence standard has been followed because of concerns about the fact that as a lay panel, close calls may be difficult. The flip side of that is that the standard, if someone were to bring a case in a civil court, is just preponderance of the evidence. I would note that S103, which just left House General and is on its way to House Education, would change the standard in employment and public accommodation so that to reach the unlawful standard, it no longer has to be severe or pervasive conduct that the entity allowed to occur or did not take reasonable action to prevent continuing when they became aware of it, to just any discriminatory action if the entity becomes aware of it and allows it to continue or doesn't take reasonable action to stop it, would potentially be actionable. If that becomes law, I would suggest changing this standard to preponderance of the evidence, because that's the standard we would face in court. In this case, our standard of proof here does not require that conduct be severe or pervasive to be a violation. So we've insulated ourselves by saying we need it to be proved by clear and convincing evidence, but you don't need to show that it was severe or pervasive discrimination for us to take action. Any discrimination violates the policy. So it does leave the question open. I don't know what the prospects are for 103 now that it's out of general. I don't know if education will get it out by the end of the semester or if the Senate will have time to act on House amendment. But it's just something I need to highlight. So we can wait.
Yeah, I think that one's a wait and see, and if that's,
Yeah.
if we have to come back and make one change based on a change in the law.
Yeah.
That's okay, unless, go ahead, Elizabeth.
It also changes preponderance of the evidence to totality of the circumstance.
Well, so preponderance of the evidence is, so they're actually two different parts of the same big issue, but preponderance of the evidence is when you're weighing the evidence after you've received all of it and you consider all of it, which side of the scale has got more evidence on it. Totality of the circumstances says that you have to look at the totality of the circumstances surrounding the event. It doesn't get to when you decide that the conduct occurred. It just tells you what you have to consider. So that's, and that's existing law that's being codified in 103. So we would already be encouraged not to look at an incident in isolation, but to look at it in the totality of the circumstances. So for example, if this is the third time in 4 years that an individual has used a racial slur with another individual, we wouldn't look at just the most recent racial slur. We'd look at the history. And, you know, so that's what we're getting at there with totality of the circumstances, is we'd look at what was the context, what's the history, is there discrimination on other basis of other characteristics? So is it not just racial discrimination, but also comments about a person's religion or about their sexual orientation or the color of their skin, whatever it is?
So is the question, would it be wise for us to add that to this policy, or
I
is that
don't-
not necessary because
I don't think
It's
we
already-
we wait.
need
Yeah.
to.
Yeah.
So what S103 is doing is addressing an issue that arises in applying court precedent, because depending on the judge, different precedents are applied to each case. And so what 103 does is it takes certain precedents and says, courts, when you're considering a case, apply these particular precedents, which go to considering the whole of the instance instead of saying, well, that one instance of sex discrimination, that wasn't unlawful by itself. And the one instance of racial discrimination wasn't unlawful by itself. And the instances of religious discrimination weren't, under the current law, sufficiently pervasive or severe. Instead of saying, wow, this person was subjected to sex discrimination, racial discrimination, and religious discrimination, this was a really hostile working environment. Because that's what the person experiences, versus saying, you know, on Thursday I was discriminated against on the basis of my sex, and then on Friday they commented on my religion, and the week after it was my race. So really it wasn't hostile or offensive. It's just 3 separate incidents that, and that's the issue, that some courts have applied the law to say, no, we'll consider each one separately, when the reality is, if you're looking at a hostile working environment,
it's all in the
It-
same.
every day
Yeah.
you go to work as part of that working environment. So anyway, and that's been a problem with the courts, not necessarily in Vermont, but that one court will apply it one way, one court will apply it another, and it's not consistent. And so your results in these cases can depend somewhat on the judge or the circuit or the district you bring your case in, because it depends on how they're going to apply things. So part of what 103 does is standardize some of the precedents out there. But anyway, that's what I was just talking about when I was late coming up here. So let's,
Okay, well, we'll come back to this at a later.
okay,
date
so for now, take it out.
Yeah.
And then consider it.
After the session, then.
Yep. Okay. Just, well, okay. Zoom likes to roll down its taskbar, which you can't see up there, but it's incredibly annoying when you're going to save your document. I just need to save it as a new version before I accidentally overwrite my old version of the document, so bear with me. And I like to do this just in case you say, we want to come back to that language we discussed that day, and I can't find a copy of it. I can always go back in my versions. So this changes the public statement to, after imposition of publicly noticeable corrective actions, the chair, in consultation with the speaker, would issue a public statement rather than the panel chair or the speaker as appropriate. Okay, good. And the last is a rewrite of the confidentiality section. So in order to encourage persons who believe they have experienced discrimination to feel comfortable contacting members of the panel and pursuing a resolution through the panel and panel staff shall maintain the privacy and confidentiality of all parties that contact the panel to the greatest extent possible as provided pursuant to this section. And then in B, except to the extent necessary to investigate an alleged violation of the policy, to carry out the provisions of these rules, or as permitted pursuant to subsection C, the panel and panel staff shall keep confidential any information obtained, all panel discussions and deliberations related to an alleged violation, and all records produced or acquired in accordance with the policy and these rules. So essentially, anything relating to a violation of the policy is confidential, except as necessary to investigate the alleged violation, because you may have to disclose identities, to carry out the provisions of the rules, for example, referring a complaint or providing notice to a respondent that there's a complaint filed against them by another member or by another individual. And then in subsection C, we provide authority for a complainant to grant the panel and panel staff a limited waiver of the requirements, confidentiality requirements, to communicate with entities that have jurisdiction over the incident, conduct, or alleged violation. In other words, this could be that you have a complaint that's both discrimination and sexual harassment, or that involves a member of the Senate and a member of the House. So you could have 2 or 3 different panels involved. It may involve an ethical violation, in which case you could involve the ethics panels, or it could involve someone who's a member of, let's say, the executive branch, in which case we would need to communicate with the Department of Human Resources regarding their procedures, or maybe this relates to an incident that's subject to an investigation being carried out by the Attorney General or the Human Rights Commission. All these different instances where you might need to communicate with another body, so we're not working at cross purposes. So that's what this allows. And then the rest is just renumbering. And then in the appeals, instead of saying statement twice in 6 words, I just said a concise written statement.
It's my
Yes.
favorite irony of the day right now.
Welcome to being a lawyer. I never said something in 4 words that I could say in 40. I hope that's not true, but sometimes when I reread my stuff, I'm like, what? So this, just shortening it up, and then the last piece for maintenance of records in cooperation with human resources and legislative IT. And this really gets to the effort to create a secure digital repository for communications, so that we don't have the communications over email. And so that only members of this panel, for example, if we put, instead of, so when I draft a document for the panel, it goes into our regular document management system, and I can restrict access to it. But I have to remember to actively do that, and putting it on a secure, what we're working on with IT right now would allow any member of the panel to edit a document that's up there or to view it. And Arlene and I will have control, administrative controls to lock documents once the panel has finalized it, so you can't change the record. And then also to send documents for editing, but it would only be members of this panel and Arlene and I, and then IT, if they need to get in there to fix something, would have access, and there will be a chain of custody. So you can see who accessed a document on what day. So if there are questions, or if there are concerns that something leaked, we'll have much better security controls going forward. But to do that, I need to be able to work in consultation with them. So that's all of it. Are the changes okay?
Yes.
Yes.
Yeah.
Apart from the small edits we made, are there any other changes?
I adopt the version that we just reviewed.
Is there a second to that?
A second.
Any further discussion on the motion? All those in favor, say aye.
Aye.
Any opposed? Nay. Ayes appear to have it. The ayes do have it. Fantastic.
Okay.
We have edited the policy.
Great.
Thank you.
I will clean it up and send a clean version to Lindsay and the panel, and then she can post that when it's ready. Probably sometime early next week, because the way my day has developed, I thought I had a lot of time.
Yeah, it's okay.
So,
This is
yeah.
So the other thing on our agenda was going over the Social Equity Caucus protocol and information for committee hearings. Elizabeth, do you want to go over that with us, or?
Sure.
Let's see.
Can I, before you get started, are we confirmed that that's gonna be included in the discrimination prevention training? Jill confirm that, I know you sent it to her, I just didn't know.
Ask for confirmation, right? There's no design.
I would say my assumption is no, only based on the fact that it is a 1 hour.
An hour and 15 minutes.
Hour and 15 minutes, exactly.
Sounds.
What? On Tuesday?
Yes, May 2nd. If it doesn't get incorporated into the training that we're gonna be doing on May 2nd, I think there's plenty of time to make sure it gets incorporated into the trainings that happen when we come back in January. But
Because now we have a solidified
we're a
trainer.
trainer that we can work with on developing more comprehensive, I mean, this, what's gonna be happening on May 2nd has come together in 2 weeks. So,
Yeah,
but Jill did acknowledge that I asked her to look at it, but I haven't gotten confirmation that it, but I will ask.
yeah, but I mean, at a high level, do you wanna go over that and then we can?
Okay. Sure. So at a high level, this provides guidelines for committee chairs and other committee members on how to treat witnesses. We have heard, or I guess I can't speak for, or not use the royal we, but I've heard of many incidences where, or incidences of witnesses being treated very poorly. I've witnessed myself totally inappropriate treatment of witnesses and totally inappropriate treatment of committee members by witnesses as well. So this provides some guidance for committee chairs as well as other committee members, and also for witnesses as far as what they're able to expect from committee chairs and committee members and committee assistants, I believe. So it also gives resources for when something happens that's inappropriate in committee. That's the highest level. I don't really want to read the whole document to you.
No, I didn't think you were gonna read the whole document.
So,
Go ahead.
so this is just like everyday committee?
Yeah.
Oh, okay.
Yeah.
Gotcha.
And part of the reason that it's being brought up now is that there was an incident in our committee, general and housing. And I think we talked through it pretty well, but the Republican members of our committee asked to be trained on this document. So it got then brought back up to House leadership.
Do we, I think at some point it would be helpful for for us as a group to go through this in its entirety. I don't think today is probably
No,
good for that. But let's keep it on our radar to do, for sure. I think it would be really helpful. So there was nothing else on our agenda, so is everyone comfortable with adjourning?
Yeah.
Okay. So, but do we need to vote on that?
No, you're just.
We're